Okay, so about us, the JIIPCC Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria, Africa, and the world. You can watch our videos. I'm sure you all have been following us on YouTube and on Facebook because it's like the best opportunity you have to refresh all you've learned in case you miss anything during the sessions. It's always there on Facebook and YouTube for you to catch up with. So the objective of this program first is to provide easy access to intellectual property guidance, training, and resource material for students, young lawyers, and IP enthusiasts in Africa. It is also to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders. It also aims to transform mentees into intellectual property mentors and leaders for the next generation of mentees. And it helps to facilitate further intellectual property mentorship, internship, scholarship, and IP-related job placements for the mentees. And okay, so this week, this is the 5th week, and we have 3 amazing mentors. 3, I'm sure you've heard of them already. They really do not need much introduction, but as is expected, I'm going to read their profiles here just to give us something to expect. Let's start with Senator Iheye. Now, Senator Iheye is the lead partner at Efficient Lawyer, where he heads the blockchain practice and intellectual property and technology practice of the virtual law firm. He advises both local and global companies in various areas of law, including emerging technologies such as blockchain. A tech lawyer with interest in policy and regulation, Senator is the president of Stakeholders in Blockchain Technology Association of Nigeria, CBAN. He is also the current General Secretary of the Blockchain Industry Coordinating Committee of Nigeria. He is the exclusive contributor, that is the Nigerian chapter exclusive contributor to the International Guide to Blockchain, that's 2020 edition, as well as exclusive contributor to the Comparative Legal Guide to Data Protection 2019. Senator is currently the first Vice Chairman, Intellectual Property Committee of the Nigerian Bar Association section on business law and member of the Information Technology Committee. As I said, it doesn't need much introduction. Now, the next person on our next mentor that we'll be hearing from today is Ridwan Oloyede. Now, Ridwan is the co-founder at Tech Hive Advisory. He advises on the global aspect of technology policy, data protection, and privacy law, digital health, digital ethics. He rolls out of new and disruptive technologies, data governance, and cybersecurity law. He co-founded African Data Governance Initiative and the Private Alliance on International Organization, providing businesses with global privacy solution, and leads his West African operation. Ridwan is a research fellow at the African Academic Network on Internet Policy and an International Associate of Privacy Professional Fellows of Information Privacy. That's the second person. And the third person will be, the third mentor for today is, let me share this, is Favor Borokini. Now, Favor Borokini is a technology policy researcher with a law background in Nigeria. In our role as data and digital rights researcher with Policy, a Ugandan civic technology non-profit, she researches a number of knotty topics related to technology-facilitated violence against women and the general impact of subsisting and emerging technologies on social justice and equality. She also works as a content writer with Ethical Intelligence, an AI ethics consulting firm, and various research groups on topics related to data protection, regulation, healthcare delivery, and is currently an affiliate of the Future Society. Now, those are the three mentors we'll be listening to today. And trust me, you really don't want to miss a moment of today's session. So as is the practice, we're going to go on to presentations by the groups. Please note that you have 7 minutes for each presentation. And today I would not be extending your time. I'll be stopping you at exactly 7 minutes. So please try to keep to time. So we're going to start with the first group, group one. If you're okay. She's here.
Yeah. Good evening, everyone.
Okay, thank you. Remember, you have 7 minutes.
All right, thank you. My name is Esohe, and I'll be presenting representing group one. So today we're discussing intellectual property in blockchain technology. Next slide, please. And we'll be looking at the following: what is blockchain technology, the scope and types of blockchain technology, relationship between IP and blockchain, blockchain in copyright, trademark, and patent, benefits and challenges of blockchain technology in IP, and the future of blockchain in IP. Before we go to the definition of what blockchain technology is, I would like to take us back to the 90s, where if you were told that money could be sent through the internet, I'm sure you would have stoned whoever told you to death, but that is the case now. So the internet of the 90s was called the internet 1.0, which was the internet of the first generation, and it is now called internet 2.0, that's internet of the second generation. Some even go ahead to call it internet 3.0, that is internet of the third generation. Now, what is blockchain now? Blockchain is seen as an interconnection of computers where you trace nodes. Nodes are computer networking. Then Senator Ihe defined blockchain as a distributed ledger or database, which can be private, public, or hybrid, where anything of value, including currencies, identities, information, intellectual property, securities, votes, etc., can be stored, moved, or managed efficiently, securely, and transparently without a central authority or third party. Blockchain doesn't have, it's decentralized, meaning it doesn't have a central authority controlling it. If you remember some weeks ago, Facebook was put on a halt and everyone was on a standstill. The whole world was put to a still. Why? Because it's controlled by a single head, Mark, and his people. Now imagine blockchain is nothing like Facebook. That is why it can never be put on a standstill. It always operates itself. It is decentralized. Now, with blockchain, you're able to see all your data and control who sees your data. Now, one of the most important thing about blockchain is encryption. Encryption is the process of obscuring information, that's hiding information, making it unreadable without a password. So if you don't have passwords for your blockchain, you won't be able to go into it. Now, what are the types of blockchain that we have? We have public blockchain, we have private blockchain, we have hybrid blockchain and consortium blockchain. Public blockchain is everyone has access to it, and you have access to this blockchain when you are in possession of what we call public keys. Now, for private blockchain, it's not like when I give you the pin to my ATM card, you can withdraw money from my bank account and you can send money to anybody as you like. That's what private blockchain is all about. Now, when we think of and a hybrid blockchain is the combination of public and private blockchain. When we think blockchain, what comes to mind mostly is cryptocurrency. But I would like you to know that cryptocurrency and blockchain is way beyond rather cryptocurrencies. It deals with identity, securities, intellectual property, information, and the likes, votes, and so many other things. Now, what are the relationship between blockchain and IP? I would like to talk about copyright now. If you let me ask a question. Let's say I send you the PDF copy of my work. Will you lose your copy? Will I lose my copy of that work? I won't lose that copy. But this is where the relationship of blockchain and IP comes into place. Now imagine your work is copyrighted and I send you the PDF copy of my work. I'm supposed to lose that copy so that authors do not lose their money. And that is where the relationship of blockchain and IP comes into place. Now, with the advent of the internet, the challenges associated with copyright protection have become larger. So for authors to gain royalties, their work has to be protected. Now, blockchain itself is a technology. So that's where patent comes in. So patent, it has to be protected by patent for it to be successful. So blockchain itself is a kind of database, and database is a collection of information stored electronically on a computer system. While database is into tables, blockchain is into blocks. So every information stored in blockchain are put in blocks, and then when a new information is stored on the blockchain, it connects to that previous information to make it traceable. Next slide, please. Then also, Satoshi Nakamoto, when he introduced what we call the white paper Bitcoin, one of the major problems he wanted to solve was the issue of double spending, like I said before. So how will copyright protect, how is copyright supposed to protect your information in the blockchain? It does this by, when you send a PDF copy of a book you bought in the blockchain, when you send it to someone else who has not paid for it, you will lose rights over that book. Now that is how copyright protects your information on the blockchain, and also trademark protection. Next slide, please. Blockchain, I've talked about this. So let's move to the challenges of blockchain. So there's a case study in 2017. Okay, benefits of blockchain to IP. Sorry. Now blockchain protects. Sorry, can we look at the benefits? Okay. It protects against unauthorized sharing of copyrighted content. It also helps copyright owners audit their royalties. I've explained that before. It offers a high level of automation. Implementing blockchain allows for a tamper-proof chain of evidence for intellectual property, and it allows you to trace works that have been patented, works that have been copyrighted also. Next slide, please. Challenges. Can we move to the challenges, please? So what are the challenges of blockchain? Now, blockchain is data intensive, and there's cross-jurisdictional issues. So imagine a work, can the integrity of blockchain-based data be guaranteed, and how would providers and users handle data protection? So imagine there are no strong regulations to implement blockchain rules in country and other places. So imagine there's a different law in another country and there's a different law in your country. Which authority will preside over an issue that has occurred in a particular jurisdiction? So we need to consider all these things. And the future of blockchain, please, next slide. So looking forward to the future, blockchain has the capacity to transform intellectual property protection, and the hope is for jurisdictions to embrace this technology. So it will really be helpful if jurisdictions around the world can embrace blockchain technology into IP. And this is what it's going to look like if we infuse blockchain technology into IP. It will help in determining creatorship and proof of ownership. It also help in solving the problem of double spending. Yeah, it's also help in solving all of that. It's also help in unifying global patent, trademark, copyright, industrial design system. So I hope that with with my explanation, we are able to understand IP and blockchain and see that there's a future in it, and it's going to be a very beautiful and bright future. Thank you.
Okay, thank you very much, SA. Thank you. Thank you for keeping to time. You overshot it by a minute, but thank you, sir. Okay, so I'll be calling the next group. That's group 4. Group 4, please, and start your presentation.
Good Hello, good evening, everybody.
Good evening.
Okay, I'm just waiting for Usman to please share his screen.
Can you start?
Okay, that's fine. Yeah, so our topic is IP and technology, IP in the artificial intelligence industry. So I'm just going to give a very brief definition of what intellectual property is. So intellectual property, can you hear me?
Yes, we can.
Okay, thank you. Intellectual property is, the creation of the human mind. Yeah, so let's just have that, that definition in mind, and then I'll come back to that. So artificial intelligence now is, yes, so next slide is artificial intelligence. So artificial intelligence is defined as intelligence demonstrated by machines as opposed to the natural intelligence displayed by animals, including humans. So basically,
can you use your mouthpiece? Put it a little closer.
Oh, okay. Is this better now?
That is so much better.
Okay. So artificial intelligence, it was first coined in 1956 at a Dartmouth conference by John McCarthy. And it basically defined it as the science and engineering of making intelligent machines. So basically, in simple terms, artificial intelligence is intelligence that's carried out by machines instead of human beings. Next slide, please. So notable examples of AI, manufacturing robots, we'll hear of self-driving cars. We know of this product, Apple does, Siri and Alexa. You can be anywhere and then you can talk to Alexa to play you a song or call a number. That is artificial intelligence. Virtual travel booking agents, where, you can just go on a website and through the creation of the AI, your ticket can be booked for you. Next slide, please. Yeah, so there are different rights that, are accrued to artificial intelligence. You have your patent, your trade secret, your copyright, and your trademark. So I'm just going to briefly touch on these 4 rights that accrue to artificial intelligence. So for patents, we know that patents covers inventions, notably inventions, and we know that it has to be of industrial application. So the process used in making the artificial intelligence must be disclosed in a detailed manner such that any person skilled in that particular area can be able to put it together. Next one is trade secret. So the trade secret allows the inventors of the AI to keep confidential the process as used in making the artificial intelligence. So for copyright, how is copyright, connected to artificial intelligence? So where you have the processes of the artificial intelligence, where it is broken down into a book, like into a textbook or into a manual or into a guide that, someone else can read through that manual to be able to produce whatever it is that the creator of that manual wanted for you to be produced, then it can be copyrighted. So for trademark, trademark creates a connection and an indication between the product and its creator. So if we hear of Siri, if we hear of Alexa, we immediately think of Apple. So through trademark, that can be protected. So advantages of artificial intelligence. Because it is machines, because it is computers, there's less human error. And, for that, it's available 24/7. You can go on any website where, that is enabled. When you want to now book your tickets, you can go on any website that, that has AI in it, and nobody is telling you that, oh, this system is short or the person in charge of it is short from 8 a.m. to 9 p.m. 24/7 is always there. Decision making is faster when using that, and it takes risk instead of humans. Disadvantages of AI. So one of the disadvantages that it requires a lot of money. For you to come up with something like that, a lot of money has to be expended. So if you do not have that sort of money, it's going to now be a disadvantage for you. Another disadvantage is that AI on its own cannot produce something. So AI works if there's already a foundation. So the creator first has to, put in data that AI has to feed from. So it cannot just produce an artificial intelligence stuff and think that it will work on its own. It has to be fed with already a pre-existing data for it to, go on creating other innovations. And gradually, in China now, most of the restaurants, so for waiters, they replace their waiters with robots. So that means that unemployment rates will be sort of increased in that area. So, I mean, yes, we're happy that, technology is advanced and all of that, but then on the other hand, most of us will be out of jobs. Another disadvantage is that because people who are meant to be doing these jobs are not doing it, there's a tendency that, they forget about how to do it, and, they tend to not use their brain more often. So controversies surrounding AI. So when I started this presentation, I said intellectual property is the creation of the mind. So now AI is creation from machines doing what humans are meant to do. So now the problem is where an innovation is created by an AI, who then is the owner of that creation? Is it the AI itself or the programmer? When we were having this discussion on our group, I remember saying that it is only fair that if I am the programmer and I give my machine, okay, this set of data, and it has done what it's meant to do, but then it goes ahead to create something else, it is only fair to acknowledge that this machine was able to create this particular thing because of the pre-existing data I had given it. So it's only fair that I should be the one, to be the owner of the invention, sort of. However, some countries like Australia and South Africa, they've permitted AI systems to be qualified as inventors. However, in countries like the US and the UK, to them, no. AI they cannot have a life of their own. It's, it's the programmer or wherever it is that fed it with the data that is the creator of that is the owner of that invention, basically. And then again, if we say that, okay, yes, it's the AI that is meant to be termed the inventor. So what then happens when, the rights of the AI now is abused or is violated or is exploited in a way it shouldn't be? Who then has the right to, fight for that, or who then has the right to protect such, such infringement if we're saying that it's the AI itself that is the inventor? I don't know if my point has been passed for years. So in New Zealand, it vests, the copyrighting works that's created by these programs on the programmer. Okay, so in conclusion, according to WIPO, as AI continues to emerge as a general purpose technology with widespread applications throughout the economy and the society, this poses fundamental questions that sit at the heart of the existing IP system. Does AI innovation and creation need IP incentives? How should the value of human invention and creation be balanced against AI innovation and creation? Does the advent of AI require any changes to the existing IP frameworks? And we can all agree that yes, the advent of AI requires that changes should be made in our IP frameworks, because one, the definition itself already negates that. The definition of IP says that it's the creation of the mind. AI is a machine, it doesn't have a mind of its own. And with this, we hope that we've done justice to this topic. Thank you very much.
Okay, thank you very much. Thank you. And I must say, you've asked some really crucial questions. Touching on things like the unemployment that will follow when artificial intelligence becomes mainstream. But I'm sure our mentors will address that. Okay, so we'll go to the next group. We've listened to group 1 and group 4. So group 2, group 3, if you're ready, let's start with group 2.
Group 2 is ready.
Okay, thank you. Please.
Okay, good evening, everyone.
Good evening.
My name is Ofure, and I'll be making a presentation on behalf of Group 2. Our focus is intellectual property in NFTs and smart contracts. And we're able to break down the topic into an outline, and the outline is on our slides. So while I wait for the slides to be shared, I'll just go on. So first, what are NFTs? NFTs are non-fungible tokens that are verifiably unique representations of digital and physical goods. They are basically the digital versions of certificates of ownership securely recorded on a blockchain ledger. Each NFT generally differs in makeup and therefore they differ in value, unlike physical currencies like the dollar, which can be exchanged for each other and no value will be lost. So we made a difference between NFTs and digital currencies like cryptocurrency and the rest. So first, NFTs are fungible, while digital currencies are NFTs are non-fungible, sorry, while digital currencies are fungible. NFTs cannot be traded for each other because, yeah, they do not equate in value, while digital currencies can be transferred transferred for each other. NFTs are centralized and regulated by the community which run them. Digital currencies are decentralized and regulated by authorities like banks and the government. NFTs are accessible through a digital public ledger, making transactions transparent and open. Digital currencies are assessed, they are private, yeah. So transactions are confidential. So now intellectual property and NFTs. The concept of NFT is particularly interesting when it comes to intellectual property law because IP law often protects intangible assets like inventions, song, or logo. We discussed how NFTs can be protected by various or certain IP rights. First, copyright. Generally, copyright is vested in the creator of a work. The purchaser of such work only owns the digital item. So this ownership granted to the purchaser often comes with rights like right to resell, display, or some other limited rights that can be stated in an agreement. So such purchasers do not receive the rights to the creative work because rights remains with the creator. Now, trademark. NFTs can be used in conjunction with physical objects and brands to show authenticity. This to make the trademark holder to get the opportunity to enforce such their trademark protections, and customers will be able to identify fake products. So basically, trademark issues under NFT arises where the creator of an NFT improperly uses a trademark that's registered for another product in their work. Now, licensing brands or artists can license their brands to NFT creators to display or resell their creations. This is like National Basketball Association that grants license to users to buy, trade, and collect NFTs of official NBA content. And then just like any other licensing property, several IP issues can arise from this. NFTs can also be protected through patents. For instance, Nike through CryptoKicks, they have obtained a patent for generating cryptographic digital assets for footwear. Now we should note that NFT are primarily sold on various platforms like NBA Top Shots. Now these platforms comes with terms of service that define the IP rights that comes with such NFT. The common form of license that comes with such sale is non-transferable, and so the purchaser of such sale do not have the IP rights to sell the NFT or the assets that comes in it. If even when an NFT creator gets the license to get the license to display an asset in an NFT, an originally existing work of another person, he does not have the right he does not have the right to charge a fee to view or display such NFT. So the assets are basically the 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 intellectual property right remains with the creator of such work. Now, what are smart contracts? Smart contracts are automated, immutable, and irreversible agreements between the contract creator and the recipient, written in a code and baked in blockchain. It is a computer program that is intended to automatically execute a legally relevant action according to terms of contract. Now, Nick Szabo first introduced the concept in 1997. Smart contracts have proven to automate tasks which traditionally would have required third-party intermediaries, high enforcement costs, and then it prevents fraud, losses, and malicious or accidental exceptions in contractual agreements. Smart contracts should be must be distinguished from smart legal contracts, which refers to legally binding agreements with terms expressed and implemented in machine-readable codes. Now, a smart contract is not necessarily a valid binding agreement at law. Scholars have said that they are not legal contracts at all, but that they are simply a means of performing obligation that derives from other agreements. It has also been argued that the imperative and declarative nature of the programming languages used in the smart contract can affect the legal validity of the smart contract. The differences between blockchain and smart contracts. Now, one, blockchain is a digital network that allows for storage of information, data, value, and assets. It can be specific and time-bound, and this makes it different from smart contracts, which holds and executes series of information and programmed data. Smart contract is a computer software for performance of obligation. And so blockchain it's general. It can house as many smart contracts and also as other assets that are uploaded on it. Now, IP and smart contracts. The immutable nature of blockchain provides a history of ownership and creation that cannot be tampered with. And just like Eseohe mentioned, using smart contracts with blockchain technology adds a layer of security to the contract and can be used to provide licenses to obtain royalties. So smart contracts has increased the utility of implementing blockchain to protect one's IP. Now, NFTs and smart contracts. NFTs can be embedded within smart contracts, and the smart contract has the ability to own an NFT. So this can be transferred based on specific terms predefined in the smart contract. So now a user can access a digital asset within an NFT through a smart contract. The user agrees to the terms in the smart contract and pays the agreed amount of digital currency. And then when all these conditions are met, access to the assets in the NFT is granted. Now, came up with some challenges that arises from the application of IP in NFT and smart contracts technologies. They include that the infringement of the IP right of these technologies are not clearly defined, and so the implications of such infringements are not clear. The digital assets can be easily copied, mixed, and shared, and this has led to a retreat of the law in the protection of the IP rights that comes with it. There's little or no legal regulatory framework for blockchain generally around the world. There's difficulty in enforcing the IP rights attached to the NFTs and smart contracts. Now, there's also no legal definition of these technologies around the world, and this has made it difficult to come with a solid ground of compliance. There's ignorance, gross ignorance in them, of the true facts that surrounds them. Now, we came up with some recommendations, and they include that a clear regulatory framework is required to provide protection of the IP rights accruing from the use of NFTs and smart contracts. Government policies affecting the blockchain industry in general are encouraged. The government agencies concerned with the regulation of the blockchain industry and other related matters should be educated about the space. And then lawyers generally are encouraged to gain knowledge about these technologies to enable them prefer the right solutions to them, to IP issues that arises from them. So in conclusion, the blockchain technology is still developing as well as its various aspects. It's obvious that the law is trying to catch up with it, being a technological innovation. What is expected is a favorable regulatory-based approach by the authorities, as the government, and a cautionary adoption approach by the public. So I hope we've been able to do justice to this topic. Thank you so much. This is the team.
Thank you very much. Wow. Okay, thank you for that presentation. You really addressed some questions I have been having about NFTs. I've always wondered how people make money off something like that. Well, thank you. Okay, as you know, okay, so far we've listened to 3 groups. We have 2 more to go. So that should be group 3 and group 5 if you're available.
Yeah, we're ready to present for group 5.
Okay, group 5. Thank you. Please.
Right. Hello everyone. Good evening. My name is Simi, and the person that's supposed to share the screen had to attend to an emergency, so I'll just do that from my side. Okay.
is here. Thank you. All right, so group 5 had to do research on intellectual property for the fintech industry. So we'll be going straight into that. All right, before you talk about intellectual property in the fintech industry, you first have to understand what the fintech industry is. So next slide, please. All right, so it is important to note that, yeah, go on, next slide. All right, so fintech basically means financial technology. When you think about fintech, two things should come to mind: the financial industry and then the technology industry. And it is basically a blend between these two industries. So financial technology is used to describe any technology that seeks to improve and automate the delivery of financial services. And it is utilized to help companies and owners and consumers to better manage their financial operations. So yeah, technology in the financial space is basically utilized to ensure that operations are run more smoothly, and then there is more efficiency in the running of the operations. Next slide, please. All right, so broadly speaking, financial technology can apply to any innovation on how people transact business in the financial industry, from the invention of digital money to double entry bookkeeping. So next slide. Next slide. All right, so like every other creation of the mind, financial technology is also protected by intellectual property rights. That helps to acknowledge like ownership rights, the creators, and also helps them to be used in an appropriate manner by consumers, basically prevent people from infringing the intellectual property product. So since competitive technology is innovation, understanding the issue, associated with the development and the deployment of IP is very crucial. So yeah, at this point in time, I would ask you if you're finding it interesting, and if we can move on. We try to make it as succinct as possible. But yeah, so the table you're looking at right now basically deals with the fintech companies and the regulation, like the regulatory framework around it. And if you can look at the top left of your screen, you will see that there are IP rights right there. So yes, next slide, please. Okay, so first we'll talk about patents. Patents would basically center on the software aspect of financial technology, because they are inventions, innovative inventions. So the patents would cover that area. So patents provide a mechanism to exclude others from making, using, selling the patented technology, which may help the companies obtain or maintain market share. So as with every other invention that patent protects, software is protected in the fintech industry, because the owners, the creators of these works would want to ensure that it is not being exploited improperly. When you think about other products that patent protects, like medicines and all of that, you see that only certain companies have the right to produce the drugs and distribute them. So the same thing applies to software in the fintech industry. When a software is created to ensure like more efficient and effective running of a financial process, then yes, the patent will cover it, and patent is one of the aspects of IP. Next slide, please. All right, so patents are considered to be one of the core assets of technology-related companies, because they enable the companies to exploit the patented invention exclusively within the stipulated time before releasing it to the public domain. And also it precludes others from exploiting the invention without the inventor's consent or authorization. So fintech companies utilize patent rights to protect the inventive steps that they have come up with in the process of simplifying their financial offerings to their consumers. So yes, next slide, please. All right, so obtaining patent protection is quite lengthy and a costly process in comparison with other intellectual property rights. However, there are international agreements that allow the postponing of expenses but guarantee early commencement of protection for important innovations. So what this simply means is that because of the process of obtaining the patent is quite rigorous and lengthy and can also be expensive, the international agreements that are put in place would allow an inventor first offer its product to the market, and probably when you generate revenue or profit from consumers patronizing you for that invention, then you can pay later on. And I think that's a very laudable invention by international agreements. So yes, next slide, please. So next we go to copyright. Next slide. Copyright automatically extends to computer codes, visual interfaces, audio. When you think of copyright, it protects literary, artistic works and all of that. So yes, when you write the code down, it is going to be like you write it in a piece of paper or like you just document it in some sort of form. And even if you record it, like the audio version of it, it's going to be protected by copyright. So aside from the invention itself, any other reproduction of it in like a literary or audio form, visual or audio form, will be protected by copyright. So yeah, can we move on to the next slide? So fintech companies may also benefit from placing digital locks on copies of their works to provide additional security, and circumvention of the digital locks is an offense in some jurisdictions and may provide relief against unauthorized parties. So this is basically talking about infringement. The digital lock is like an extra step that is taken by fintech companies to protect their inventions, and once it is circumvented by any other unauthorized party, then yes, they will be in breach and will be liable at law. So next slide, please.
Please take note that your time is running out. And
okay,
so,
okay, thank you. Next slide, please. Okay, so I'll be brief. So yeah, the idea is that fintech companies should be vigilant with the policies for developers incorporating third-party copyrights, even if inadvertently, as it may impact the ownership of technology and freedom to operate. Next slide. Okay, so yeah, we haven't spoken about some aspects, and one of those aspects is trademarks. Can we move on to the next slide? So the word, mark, logos, domain names, and the icons used by these companies are protected by trademarks. So when they put like a particular logo or a mark to specify, like to identify an invention in the financial technology space, then yes, it must be protected by trademarks for owners that want to make it exclusive to themselves. Next slide, please. Also, trade secrets are another aspect of financial technology that should be protected. Obviously, trade secrets are confidential business information and they have economic or financial value. So every company coming up with technological products in the fintech space, we should obviously know that whatever process or information that enable them arrive at the invention or logo or mark should be protected if they want to stop it from infringement. Sorry for the background noise. Next slide, please. All right, so next slide. Next slide. Okay, so we move on to industrial designs. Next slide. So industrial designs refer to the physical and aesthetic look of the product. So for example, let me give a new credit card now that is being made. Like it's just an example, hypothetically. Let's say there's a new credit card that you don't have to insert into ATMs, you can just swipe. And then the design on that new credit card or debit card can be protected by industrial designs because it is being manufactured like in an industrial process. As long as it meets all the requirements for industrial designs, then yes, it can be protected. And obviously, we all know credit and debit cards apply to the fintech industry. So in the event that a company creates a card that you don't have to insert into the ATM and you just swoosh, or maybe it's a chip or something, yes. And the design of that chip will be protected by industrial designs. Next slide, please. All right, so we have to wrap this up now. And yes, from all that has been said, the attendees would agree that it is essential that fintech companies adopt appropriate IP strategies to protect their innovations. And having a good IP portfolio would help to boost the image and value of a fintech company, which will play a critical role in attracting investors and the expansion of the company. So thank you all for listening. I hope you have gained a thing or two.
Thank you very much, Ma. So we've listened to 4 groups so far, and we'll be listening into the last group. That's group 3. So if you're available, please.
Yes, group 3 is available. Good afternoon. Thank
Good
you.
afternoon.
So Mrs. Sakiras will be sharing the screen. But before she starts, I'll quickly take us through the outline. So we're going to be giving a general introduction. We'll explain what data privacy is, data protection and privacy laws. Then we'll look at notable case laws in data protection and privacy. Obviously, this is law, we need laws. Then we'll also look at the relationship between data protection and intellectual property, trade secrets and data protection, and ways of securing intellectual property rights in data protection. So, data privacy and data protection are terms which are used interchangeably in relation to legal frameworks that protect individuals against the negative impacts of the processing of their personal information. Different jurisdictions use a lot of terms, but data privacy seems to be the prevalent ones. So what this is basically saying is in different countries, different jurisdictions, we might have other terms that we use to describe data privacy, but that is the most popular term. So we'll go on to define what data privacy is. The English Oxford Dictionary puts data privacy to be basically information. So when we hear data, what readily comes to our mind is information. For example, you are entering, let's say you have a logbook, you are typing it into your computer, you are entering data, you are processing data. So basically information. Once you hear data, you are thinking information. Flowing from this, data as used in this context is the personal information about the person, usually referred to as the data subject. So, before I talked about information in the general scheme, but in this presentation, we'll be looking at information relating to a person. So me, for example, if I am texting my friend on WhatsApp, we are exchanging information, that's data. So data privacy, how is my data protected? What is WhatsApp doing to ensure that my privacy is protected? So data privacy has to do with the protection of personal data of individuals and the promotion of the free flow of personal data in a manner that facilitates the promotion of human rights in general and data privacy in particular. So like we all know, the Nigerian Constitution guarantees the right to privacy, and this also includes personal privacy, telephone conversations, and others. We'll see that later in the presentation. So data protection refers to the means of protecting information, like I've said. Then we'll move straight to data protection and privacy laws. So as I said earlier, Section 37 of the Constitution of the Federal Republic of Nigeria guarantees and protects the rights of Nigerians with respect to privacy in their homes, correspondence, telephone conversation, and telegraphic communications. So basically, I want to quickly explain something. So if your neighbor is standing outside and you're having a conversation, a confidential conversation, and your neighbor listens in, the person is infringing on your right to privacy, right? So the Nigerian Data Protection Regulation 2019 is the main data protection regulation in Nigeria. So that is the main law that governs data privacy in Nigeria. Other regulations include the Nigerian Data Protection Regulation, the Freedom of Information Act 2011, the Consumer Protection Framework 2016, and others. I'll give us a few seconds to quickly read it on the screen before I move on.
I think you should continue with.
I'm sorry about the interruption. I am in the hostel, so. Then we'll move next to notable case laws in data privacy and protection. So the first one we'll be seeing is Godfrey versus MTN Nigerian Communication Limited. I'll read it out now. In the former case, the court held that the unauthorized disclosure of the claimant's mobile phone number by his telecommunication service provider and subsequent unsolicited text message he received were violations of his constitutional right to privacy. A similar verdict was also given in the case of Barrister Anene versus Ethel. So I'd like to quickly tell us something. There was this case, I can't remember the name, but these companies that give out loans to individuals, so a person defaulted in their loan payments and they sent text messages to different people on the person's contact list. So in the case, part of what the company was sued for was breaching their right to privacy, because my friend has no right to know if I am owing loans or if, you get what I'm saying? So my right to privacy was breached and the court ruled in the favor of the claimants. So we'll move next to relationship between data and IP protection. Intellectual property rights management is an integral part of every data management program. This is because anyone using data has to ensure that any legal, ethical, and professional responsibilities that is owed to the data subject is met. So if I'm using something, the company has to make sure that all ethical and professional responsibilities are covered. Data privacy has been said to be in the category of right to privacy, a fundamental human right. A fundamental human right which everyone protects jealously. While intellectual property, despite being an intangible asset, gives its owners the property rights against misuse or trespass. Hence, both data protection and intellectual property have rights attached to them. However, despite conferring rights, both data privacy and intellectual properties are weakly guarded, that is in Nigeria. Despite awareness on data security and privacy, the many frameworks, standards, and methodologies out there that emphasize data security and privacy do not align how to protect and govern IP data in plain and straightforward terms. They are not expressly spelled out. We do not have proper laws that govern data privacy in relation to intellectual property. So I'll move straight to the next slide. The Nigerian Data Protection Regulation also takes a similar approach to data rights. The NDPR defines a data subject as a person who can be identified directly or indirectly by reference to an identification number or to one or more of the factors specific to his physical, cultural, or social identity. Given the restrictions of data subjects to majorly natural persons only, the current data protection regime has left a huge void regarding intellectual property rights. So what this means is in Nigeria, we do not really have proper laws that relate data privacy to intellectual property rights. The question of who owns the data, who gets access to it, and whether data is something that can be owned in the first place is yet to be settled. In the same vein, it leaves us with so many questions on intellectual property rights. Similarly, the GDPR does not recognize company rights, but just personal rights. The development of technology and the dynamism of the legal system offer an insight into privacy and data security concerns in the recent periods. Privacy has become a concern of any person, and as a result of technological process, it has put limited focus on data security. So we'll move straight to the next slide, which is trade secrets and data protection. So basically, we are relating trade secrets to data protection. Trade secrets arguably enjoy the most protection under the current data protection laws in Nigeria. The agreement on trade-related aspects of intellectual property rights sets out a standard minimum levels of protection of trade secrets as intellectual property rights and provides a definition of the information that can be protected. So basically, the TRIPS agreement provides three things that it defines three ways that information to be protected. First of all, secrecy. Whatever information you are protecting has to be secret. Of course, if you are protecting something, you are basically removing it from the eye of the public. So secrecy must be involved. Secondly, it must have commercial value. And also there must be reasonable steps to keep the information secret before you can register it as a trade secret. So next, we'll move to ways of securing intellectual property rights in data protection. In essence, both IP rights and data protection are intertwined, and they are prone to threats, thefts, and infringements due to their exposure to strangers via the internet. So the proprietary rights attached to them can be protected by monitoring information. This is done by knowing where IP data is stored, putting controls in place to safeguard it, or defining who has access to the data. Also, they can be protected by physically and logically securing IP documents. This is achievable via periodic review of access control lists and removal of those who no longer need access to the data. Also, they can protect it through implementing of effective logging, monitoring, and reporting process. Thank you for listening to the presentation.
Hi, okay, thank you. Okay, Thank you for that interesting presentation. And okay, you almost kept to time. You did not exactly do. Okay, so now that we've listened to all 5 groups, we have our mentors here. We'll start with Ms. Favor Barakini and hear her perspective. We have questions in the chat box. If you want, I can read it to you, or but however you want it to go. Please, my Favor Barakini, would like to hear your observations.
I'm trying to, okay. Yes, can you see me? I can
Yes,
see
ma'am.
me as well. Okay, good evening, everyone, and thank you so much. Thank you so much to the organizers for organizing this. I have really enjoyed the presentations and I have learned a lot. I took intellectual property while I was at the university as an elective in my final year, but I can assure you we did not learn anything related to blockchain or AI or fintechs or emerging technologies basically, or data protection even. So it's really amazing that you guys are doing this and that you are starting out so early with all this knowledge and information, and I am very certain that this will be very, very useful in helping you position yourselves career-wise. So basically, I don't actually have very much to say. My expertise, even though I did take a course in intellectual property, isn't very solid. But what I do know very much about, or significantly much about, is artificial intelligence. And I'd like to comment on the presentation by Group 5, IP and AI. So I really enjoyed a lot of the presentation, as I said, and I just wanted to comment on some of the slides. I think slide number 11 downwards. So that is beginning from the slide related to the advantages of AI. So whenever we're talking about AI, especially in Nigeria and other parts of Africa, we like to begin with the advantages of artificial intelligence, because well, what would be the point of adopting all this new technology if they pose no advantages to us, if we are not gaining anything from them, right? So AI and other emerging technologies have been touted to be the precursors of the 4th industrial revolution. So the presenters already mentioned some of these advantages, like the reduction in human error, they take risks. Well, the AI takes on the risks rather than humans, and then availability, decision making, and the mass market potential. And then when it comes to the disadvantages of artificial intelligence, the presenters also did mention already the resources that are required in developing AI, and AI cannot learn to think outside the box, which is an important part of the point I'm coming to, and the fact that AI is slowly replacing a number of repetitive tasks, and that the fact that it is automating many repetitive, tedious tasks means that there is a lot of job loss. And this final statement is rather controversial, that we tend to use our brains less and less. I wouldn't say that. but the second bullet point under disadvantages is actually a significant part of the work that I do researching artificial intelligence, and that relates to the harms which AI poses to us today. So as this bullet point says, artificial intelligence or machine learning systems are unable to think outside the box. And what this means is that essentially AI is only able to produce output that has been imputed into it. And this is very significant if we think about the sort of systems that we want to be using, we want to deploy AI in. So if you want to deploy AI in health, for instance, or you want to deploy AI in education or in housing or just about any sector, in finance, if you want to give out loans, for instance, and you have to think about the sort of data you are training your machine learning systems with. So if you feed it with data that shows that historically certain groups of people are more employable or have been employed more in comparison with other people, then you'll find that when you get job applications, for instance, and you input the CVs into the ATS or whatever system it is that you use to monitor job applications, you find that certain people will be disqualified, not because they do not possess the necessary qualifications, but because the AI looks at your past record and then it looks at this new information that is coming in, and then it selects candidates that matches what you usually select. So organizations around the world where, for instance, where we have that men have been traditionally or more commonly employed for certain roles, we find that if they blindly give over this decision-making powers to artificial intelligence without close scrutiny, that women applicants will be ranked lower than their male counterparts. So you could Google, for instance, the Amazon HR crisis, which did essentially that. So women who went to women's only schools or who were captains of women's tennis clubs or who had that marker for women in front of whatever qualifications they had were ranked lower and were not offered jobs that they were qualified for. And then another very infamous example is the Compass recidivism algorithm in the US, where essentially this algorithm predicted that Black men were more likely to commit crimes after they were acquitted, released by the courts. And so the judges relied on the algorithms and decided that it was better for Black men to remain in prison, certain Black men, of course, in comparison to white people. So you find cases where a Black person who had committed a relatively minor offense would not be acquitted or would be given a longer sentence than a white person who has committed a much more heinous crime. And the judges were relying on the algorithms because they thought this is the computer is neutral, the machine cannot lie, or the machine does not lie. But it's not like the machine is lying anyway. It's just telling you that my data, the data that I've been trained with, has let me know that white people are they possess less criminal intent than Black people. And that is, of course, very racist, but the machine did not know any better. But the programmers should have known better. People who developed that algorithm should have known better, and they should have taught the judges to not rely so completely on that particular algorithm. So there's a need for people in managerial positions to be able to know that because an AI system has predicted something or has produced a certain output, that that doesn't mean that it is right or it is correct. And of course, there are all sorts of potential cases like that could happen. I think it's especially significant in Nigeria because there's so very little research done on these issues in Nigeria and Africa compared to the rest of the world. So we have this whole body of work done in technology studies all over the world, but they are not the sort of thing that you can just blindly copy. You cannot say, well, Black scholars or Black technologists have done all this research related to AI ethics and AI bias, and we're just going to copy it when we are deploying or installing technology or AI. We need to develop our own research. We need to find out axes of oppression that occur. So it might not be sex or race, it might be ethnicity, it might be class, it might be age. So and you find that certain groups of people are systematically disadvantaged because of whatever parts of their, or because of certain parts of their identity, because of who they are, and training blindly deploying these systems could mean that we will have worse injustice rather than more justice in the system. And then, so that's also part of the controversy around AI, of course. And then to the point about creating inventions, I'm sort of torn. The presenter already talked about the controversy, I suppose, about whether artificial intelligence can be creative. I don't think artificial intelligence can be creative, but I might be wrong. I think that right now we are not necessarily at the stage where an AI can independently of its own create something without some preliminary, frameworks being set around the output that it is supposed to put out. But I think eventually we will get there. And some people say that when it comes to the art world, the world of art, we'll get to a situation where we have three types of art: purely human-made art, art made in conjunction between AI and human beings, and purely AI-made art. And I think interesting that this could lead to a sort of situation where you find that human art or art made purely by humans will be considered so rare and expensive, and it will be, sort of like it is today. That because of the labor involved, while AI created art will be sort of the common stuff that you can get everywhere. But we're not quite there yet anyway. And then, so those are basically some of the major points that I wanted to point out regarding I would not even call them the disadvantages of AI. I would just say that there are ethical issues that we need to be worried about in the deployment of artificial intelligence. So, and I'm happy that we are discussing this issue today because, as I mentioned, there's very little discussion that I have found related to this issue. So it's important that I believe that we should get to the position where, as Nigerians, as Africans, we own technology and are not merely consumers, because when you own something, then you feel more able to critique it or relate with it and modify it to your own taste. So I think that this conversation, this sort of event is very useful in building the sort of consciousness that would encourage or stimulate that sort of ownership that we need in order to constantly, foster this sort of conversations and eventually create the change that we need as it relates to artificial intelligence and other emerging technologies, especially. So thank you. I'm open to take any other questions related to artificial intelligence if anyone has any. And thank you, Juliana, and the other organizers of this event.
Thank you very much, Favor, for the presentation. Sorry for the comments on the presentation. I really learned a lot. I don't know Ridwan is saying that he would like to speak quickly as he would like to leave. So I don't know if he can also just comment and then we'll take the questions. Thank you very much, Favor.
All right. Thank you, Juliana. Hi, everyone. Okay, just to confirm, he's not a robot. All right. Hi, everyone. My name is Ridwan Oloyede again. Sorry, I need to really run for another session that I have. I didn't know I was going to run this late. All right. So, quick comment about the team that worked on the data protection presentation. Nice efforts, nice research, and yeah, I mean, the speaker too was able to articulate a thought and, of course, speak to the presentation. So we just a few points basically. As far as personal data protection is concerned today, it's primarily still focused on protection of personal information of living individuals. And the right as it is currently has not been extended to protect non-personal data, which could also be corporate data, which IP data like trade secrets, trademark information about trademark, and maybe copyrights could broadly fall under. So as the right is currently understood, or as is currently appreciated, whether from the European Union or from Europe, basically where the concepts has gained ground, and looking at it from about 40 years ago when the conventional started out, it primarily focuses on protection of personal information as also an extension of a different genre of human rights itself. So I just wanted to put that out because I know part of the recommendation, also the criticism for the law as it is right now, is how it has failed to protect non-personal data, which especially talking about corporate data. For protection of corporate data, personally, I've canvassed more around seeing how we could strengthen IP laws to protect information that sits specifically with intellectual property, IP data, trade secrets, and all of that, and also using some sort of contract or documentations to do that. But more importantly, especially as it relates to the security component, we could also use stronger cybersecurity laws where none exist to also create obligations on organizations to secure data as it is. But interestingly, one of the principles of data protection itself is confidentiality and integrity, which sort of creates an obligation on an organization to ensure security of data. Then focus for a data protection law is primarily on personal data. If you look across the spectrum in Nigeria, you find a couple of other laws like the cybersecurity law, for example, cybercrime law, for example. A couple of guidelines from the cybersecurity. For those who work on the Fintech project, for example, you find the CBN framework on cybersecurity for financial institutions and non-financial institutions. You'll also find a couple of guidelines by NCC, for example, and even a couple of other CBN regulations, also specifically creating obligations to ensure security. And in this sense, they are not specifically addressing even personal information. They speak broadly to all kinds of information, which could be personal and non-personal. So for me, that's primarily my comment. Well done to everyone who has presented today. I was able to see everyone, and thanks to Favor, who is also able to share our thoughts around the AI. Favor is someone I think it's important to listen to and to also pay attention to her work. She's quite phenomenal, especially when it comes to the AI space. And yes, so basically that's just what I wanted to point out. As it relates to questions around how IP data could be, like I said, and we could look towards some of that framework itself to see how we could protect IP data. But I also believe there could also be proprietary data that could also have personal information elements, which of course could also be protected broadly under data protection law. But then when it comes to security, especially for things like trade secret and some of the high-level confidential information that's strictly proprietary, I think we should look at a multi-pronged approach to protecting it and not just looking towards the direction of a personal data law that only looks at the personal information elements there and throw out or throw into the dust and the non-personal component. I want to believe the points I've made are probably not confusing. But what I'm saying in summary is data protection law focuses strictly on personal information of living individuals. And the non-personal elements could be protected under some other existing framework, or we could make case for some other existing framework to do exactly that for us. So thank you, everyone. Thanks for your patience. Juliana, thanks for inviting me to be part of the amazing work you're doing. And good luck to everyone. And I wish you all the best always. If you need to probably reach out to me, you can reach out to Juliana to provide my email address, or just shoot me an email or shoot me a message on LinkedIn. I'm available on LinkedIn as well. So thank you, Juliana. I appreciate it a lot. Thanks. I need to run. I apologize again. Thanks for.
Thank you very much, Ridwan. Thank you for your time and for the knowledge shared. Have an amazing weekend. Okay, so we can take the questions and the answers from Favor. Thank you very much, Favor.
All right. Thank you very much, Ma. So we have some questions here.
Sorry, so if I may just come in here, Senator is unavoidably absent, but he said that if he would be able to join us before the end of the program, he would still try to do that. But what I want to assure us is that whether he comes today or not, for the questions that we have, I would send them directly to him and he would answer them probably with a voice note, and then I'll post them on the group. But for the presentations that we had today, I think they were awesome. Thank you very much, everyone. So, so the questions on blockchain and the rest, we can keep them for Senator and I'll send them directly to him. So we can hear from Favor. Thank you very much, Favor.
Well, I don't actually know what I'm supposed to say now. The majority of the questions here, as you mentioned, are related to intellectual property and blockchain technology, which is not in my line of work. But I suppose I could actually look through some of the questions and see. Okay, so from my background, from my work in AI ethics, looking at the question from group 5, and that is question 3 is what I feel most confident answering. So I think from my observations regarding fintech, so financial technology, from an ethical perspective, I would like to say that there's a lot that needs to be done regarding. So we wrote an article, Ridwan and I actually, on the creep by. Okay, so we have this set of apps that a subset of fintech apps referred to as LendTechs, and you probably already know them. So they are all over the place whenever you go on YouTube, and some of you have probably received a message saying someone close to you has borrowed some loan or the other, and they've stolen from the company, and you need to share whatever information you have about them. And of course, that is extremely invasive. So some of the problems that we are seeing cropping up related to, excuse me, please.
Okay, so while we're waiting for her, sorry for taking over the moderation from your Motoye, but so I can see that Regina is in the house and Mr. Folar is in the house, just to acknowledge them before she continues. Okay, you can continue. Thank you.
Yes, so some of the trends that we are seeing is that, well, because regulation and enforcement of the very little data protection regulation that we have in Nigeria is so poor. So we have there's increasing infringement or, well, neglect of the right to privacy. So you could install an app, for instance, and then it would ask for all sorts of permissions. It will ask for your contact information, and some of them go through your browser history. And what they do is that they scroll through all this information and collect it for themselves. Some of them eventually do sell it to people who specialize in buying data. I think they are data brokers. And then by getting access to your browser history, they're able to analyze based on whatever arbitrary measures it is that they've designed, that these companies have designed, to see if you are credit worthy. And by determining your credit worthiness, they are able to determine if you are likely to run away with their money, or if you are likely to pay, or if you're a good person, or if you're a bad person, or all sorts of, as I said, arbitrary purposes. So this is one major trend that I am seeing. And what this means, so you have to consider what this means, for instance, for people who, for instance, do not have mobile phones. So if I do not have a mobile phone, or if the phone I have is a feature phone, if an app says that, or a company who with an app says that they cannot give me a loan because they are unable to access certain information that they would ordinarily require to be able to grant loans, then what are the implications for social justice, social equality, exclusion? For instance, there are certain groups of people who are more likely to possess mobile devices than others. Women, for instance, there's the digital divide, both in ownership to purchase internet bundles. So it cuts across class, and it also cuts across gender. And so that is one particularly troubling example of a trend. I think that the person who, group 5, the person who designed this question was looking for something different, and all I am offering are problems. But these are some of the trends, really. And then for number 2, some of the greatest challenges facing regulators. This definitely relates to the decentralized nature of the internet. It means that it is impossible to properly regulate due to the cross-border flow of data. It's impossible for you to make regulation against certain apps, for instance. It's impossible for you to, as a general example, just think about how difficult it is to ban pornography, for instance, child pornography. The servers of so many of these, for countries that are actually very, very much dedicated towards rooting out child pornography, such as the US and the UK, it is extremely difficult to do this because servers that host a lot of this data are in countries like Russia, for instance, way out of the reach of the regulators. So the decentralized nature of the internet, as much as it is still decentralized, because a lot of it is rather centralized today, owned by big tech. So this is one of the challenges facing regulators. And then you also have to think about the intersection between intellectual property and I suppose, freedom of expression, or necessarily freedom of speech, or the right to share data, or the right to communicate freely. So as I was saying, there's a particular fintech app in Nigeria. I'm not going to mention the name because I don't even remember the name, but I know that they first launched in Nigeria, and they, like all fintechs, many of these fintechs actually do, they have all sorts of policies that relate to that require users to grant them access permissions to launch on your mobile devices. And what they have done now is that they have been able to refine all this data, and they have moved from Nigeria basically to a country in South America. And they are saying that it is this information which they have gathered and which they are using essentially for their fintech app is intellectual property, that it is not open to be scrutinized or investigated by government authorities or by auditors. So if no one is thinking about the intersection between IP rights and ethics, and especially during this pandemic where a lot of big pharma corporations are holding the rights to vaccines and refusing to share them, decentralize that knowledge, then I think that this is also something that we need to think about. And yeah, it definitely poses a big problem for the government if because the government's duty is to ensure that it carries out, the duty of the government is essentially to ensure that there is justice. There is a duty that a government owes its citizens who have placed it in power to ensure that the rights and freedoms of its people are not being encumbered through the activities of corporations by private interests. But if through intellectual property, companies are deliberately resisting the rights of or the power of the government to investigate exactly what they are doing with data that they have mined from the public and which they are profiting from, then this is definitely another problem and another challenge that's facing regulation today, in addition to the decentralized nature of the internet. So those are the two questions I feel most comfortable answering, and I'd like to hand over to the organizers again. Thank you.
Thank you very much, Fa. We'll get responses. We'll get Mr. Fulani and Regina's inputs in a minute. But I have a question for you, Bebo, about, you said earlier that at the moment you don't think AI can independently create anything independently. Now, do you think there's a point in machine learning where AI would work independent of its algorithm or perhaps deviate from it? I think that's been one of the raging questions about, I think, singularity and what would happen afterwards. So do you think there's a point where it can deviate?
Well, maybe. I don't really think so. I think that there will be a situation or a position that will get to where there will be, that AI will be able to act so independently of its handlers, in quotes, that we will then say that, oh, AI is acting independently. Well, and I think that we can see some strands of that in the way programmers say, oh, this is not what we designed the system to do. We don't know why it is doing what it is doing. But when we look very closely, it is still sort of, working in line with a lot of the preliminary data it was fed with. And the problem also with artificial intelligence today is also deep learning. A lot of the processes and procedures, the ways through which AI systems are able to produce the data or the output that they do is unexplainable. That is, it operates in a black box. So there are there's a lot of research actually currently ongoing to promote the explainability of data. So if you deploy a hiring algorithm, let's say in year 2050 in Nigeria, a bunch of secondary school WAEC graduates or JAMBites have just written WAEC, and they would like to get admitted to the University of Benin. Let's use Uniben because I went to Uniben, and we look at the results and we see that the AI has decided that 50% of the people going to getting admitted into the Faculty of Law are from Benin or from Edo State, even though more than 50% of Benin indigenes, or less than 50% of people from Benin actually got the cutoff. Then the government, if this is a trend that has been noticed, and then a bunch of people come out with the comparison, and then they say, my daughter scored way above the cutoff and she wasn't admitted, it would be very useful for the Senate or for whoever is in charge of Ministry of Education or whoever has deployed this system to be able to say, okay, this is why our system did this, but in a lot of cases, it's not even very easy to say exactly why the systems have come out with the outputs that they have. In a lot of these cases, we are conjecturing that it is following historical data, the data that it has been fed or trained with. So I think to an extent, some people would like to say AI is acting independently due to this. But I think that the fact that we have to create the system itself points to the fact that, well, it has a source, like a beginning. It has something that has been trained, and then it is let go to run along with all that information. But I actually don't like to think very much about singularity or a lot of sci-fi tropes regarding artificial intelligence. I feel that the responsible deployment of AI places the onus on us, or developers, technologists, people who are deploying the systems, to ensure that we must identify the most beneficial uses of technology and develop that technology to be able to address these issues. So if we are facing crises related to certain jobs that are harmful or risky but still need to be done, then very good, we should develop artificial intelligence systems that are able to fill in the gap. But I don't know, I just like the idea of singularity, and I think that it's very much abstract, and I like to think in the short term, as much as 10 to 50 years can be qualified as a short term, actually. Yeah.
All right. Thank you very much. There are actually two questions here, and I think perhaps you tried them. Okay, the first one says that if, as you noted, that a number of fintech companies use credit scoring to determine whether to advance a loan, why does the platform attract acute debtors who are unable to repay loans borrowed? Then the second is, how can AI aid enforcement in repaying loans other than shaming the defaulters?
Well, this is an interesting question. Let me think for a minute. Well, I think that the very simple answer to the first question is that, well, I like to say that Nigeria we're not very rich in this country to begin with, number one, and that this sort of that's like generally speaking. And then secondly, I feel that the sort of people who do not go to traditional, that is brick and mortar commercial banks to get loans, on the other hand, and who would rather borrow quick loans through these apps, are exactly the sort of people who are actually unable to pay in the first instance. So I must note that not all fintech companies and not all companies who grant loans actually use use all these invasive methods, go through your browser history or your contact list or whatever information that is available about you on your mobile device to verify if you are able to, if you are creditworthy, but an increasing number do, and that is very worrisome. And even about the fact that some of them require information to your contact list, while this does not necessarily point to the fact that your contact list can necessarily speak too much about your ability to borrow a loan, it is still an egregious privacy breach. So if a person borrows a loan and they're unable to repay it, the fact that the app chooses, the owners of the app choose to send messages to people on their contact list is a breach of privacy, and it's a breach of the right to dignity of a person. So, but as I mentioned, it is a rising trend that I believe should be counteracted through regulation. And it also points to the need, I believe, to develop policy frameworks for a lot of these apps. Okay, so secondly, how can AI aid the enforcement in repaying loans other than showing defaulters? So the problem is that artificial intelligence alone of itself, and I think that this is the problem really, artificial intelligence alone of itself cannot do anything. It only assists, or it only replicates or reflects the ideas of the people who develop it. So if these creditors, these lenders, do not have any means of ensuring that people who pay debts are able to pay debts, then there's nothing really that their system can do in ensuring that debtors pay back their debts or their loans. This is all the ideas that they have, and that is why they resort to shaming defaulters, I feel. Yeah. So, and I think that this points to the fact that I must stress again that AI is a tool, or we should come to think of it as a tool. It is not, we are not tools in the hands of AI. AI is a tool that we use to enact certain purposes or certain aims, goals, and objectives. So this points to the fact that if you have an idea, if there is a bridge, a gap that you're trying to bridge, then you should come up with a solution and then use your skill in machine learning development to fill this gap, to develop a solution that can assist you in carrying out the solution that you have determined is the best or the right answers to the questions you are trying to answer. And traditional banks have figured out that if you have a custom through KYC, if a person is able to impute certain information about themselves that they go ahead to verify. If sometimes when you want to open a bank account, they will ask you for landmarks around your house, or when you want to open certain accounts, they will ask you to bring forward referees. So these are analog solutions that still work, because something is digital does not mean it's better than a pre-existing solution that still works for the most part. So it is not AI itself that will bring about the solution, but the developers themselves, the people, people who work in economics, who work in finance, people working in public policy. They are the ones on whose shoulders the responsibility to develop solutions for debt defaulting lies, not AI. So, yeah, thank you.
Thank you very much. Thank you. If that is all the questions we have, I will defer to Mr. Fulani and Regina to give their comments. So please, Regina, if you're there, brief comments, please. 2 or 3 minutes. Okay. I don't think she's with us right now. So Mr. Folarin, please.
Okay. If they're not in a position to talk now, that's still fine. I would like to thank everyone that has participated in today's session. And as I said, I would like to apologize on behalf of Senator, who has said that he will not be able to join us at this time, but I'll send our questions to him so that he can send a voice note to reply. But I want to say that Favor has done an amazing work in answering a lot of the questions and even in going beyond the AI to talk about like the ethics and blockchain and so on. Thank you so much, Favor. It's been so nice having you here. And to all the presenters, thank you. All those who shared their screens, thank you. To our excellent moderator today, thank you very much. Two of the things that I noted for the trade secrets, there was a group that said that registering it and all that. So I want to just note that people don't register trade secrets like patents, trademark, and the rest that we have to register. For trade secrets, we don't register it. One of the things that is to protect trade secrets is non-disclosure agreements and trying to keep the secret as much as we can keep it secret. And then the second thing is for protecting data and digital work. WIPO came up with WIPO proof and they have keys to it and all that. So you can also read about WIPO proof. So if Regina and Mr. Folarin are not able to, okay.
Regina.
Yes.
I was looking at group 2's question on NFTs. So it says copyright protects works that are original and in a fixed form. For an NFT to enjoy copyright protection, is it required to have had a fixed physical form? So I just wanted to drop one or two comments on this. So the requirement that copyright should be in a fixed format, I really do not understand it being in a physical form. So once it's a music and it's recorded, it's in a fixed form. The requirement for being in a fixed form is met. If it's a song and it is written down or there's a record of it, it's not in your head. That's the idea that copyright does not protect an idea. Once it's in a form, it doesn't have to be. So I don't know whether this physical form is, if it's in a CD. We know the reality. The reality now, if you have your song in the YouTube, I believe it's in a fixed form. So I don't know if that makes sense. Then the second question for group 2. Some aspects of NFTs fall under trademark law. So it says for IP rights in trademark to be enjoyed, such work must be registered. I don't know if I should first of all correct the question. So for trademark, it doesn't necessarily have to be registered before you can enjoy the rights. You just have the statutory rights to the mark if it's registered with the Trademarks Registry. So if you have your mark and it's not registered, you have a common law rights on the trademark. Then if there's a dispute, it's more difficult to prove if it's unregistered. So he said, does it suffice to register the original mark alone, or must the NFT be registered to enjoy such protection? So by and large, NFTs depends on the nature of the NFT. If it's a trademark, for instance, Messi has NFTs. If he has a trademark, if he has a mark, service mark that he's been using, registering it is different from having it as an NFT. It has a lot of copyright protectable work as NFTs. So it depends on the nature of the work. And we know that copyrights in Nigeria, at least, it's not the registration that grants the rights. So it's automatic. Yeah, thank you. I don't know if what I said made anything.
No, of course it does. Thank you very much, Regina. So I see that Mr. Folarin is still here. So I'll just give like a second if he wants to unmute and talk. So while I'm taking that second, I'd just like to thank everyone for staying tuned up till this time. And thank you for putting your videos on. Next week, we'll be talking about IP registration, infringement, and enforcement. So we also have amazing mentors that will be coming to talk to us next week. And we'll be making some announcements, so just stay tuned on the WhatsApp group so that we can enjoy our mentors better. So I'm wishing everyone an amazing weekend. Thank you, Motoye, for this moderation. Even though it was your first time, it was beautiful. Thank you. And to everyone who put their videos on, I can see Sohe, Gabriel, Jeremiah, Jude, and I think some other people to put on their videos. Thank you so much. Have an amazing weekend, everyone. Bye.
Yes.
Okay.
Bye, Juliana. Thank you.
Yeah. Mr. Folari is here. Sorry.
I joined though. You didn't even notice that I joined. Can you imagine?
I've been asking you to talk. Like I've asked you like twice.
Oh,
we even
so
waited
sorry.
for a minute for you, and you didn't.
Sorry. I'm so sorry.
Because I knew that you're interested in talking about this topic.
Yes.
I've been calling your name.
I'm so sorry. I apologize.
Okay.
I think everybody has really. I mean, one can't cover the field. I think everyone has made very valid points. I had a conversation, was it this week or last week, on we're talking about the power of IP IP and fintechs, and we're talking about licensing, and how licensing really plays a very huge role in the fintech industry, in the global fintech industry. And I think to a very large extent, that's one area that we've not really focused on here in Nigeria, especially when one looks at the role that an agency like Nota plays in that licensing process. The acquisition of foreign technology, acquisition of foreign know-how, so on and so forth. I do think that many fintech companies stand to gain a lot from using licenses, and we find that many of the developers actually use what do you call them, these general public licenses, GPLs. So we tend to find similarities between the code that is used to build one app and the code used to build another app. Same thing with the business model and so on and so forth. So I think that's one area that it would be good to have like an extended conversation on. So what's the nature of the licensing regime that we should adopt, and then should we have some uniformity in that space? I think that's also a big issue, because it almost seems as if the fintech guys are all friends, and all across the world, fintech companies fight for their their place in the market. But like in Nigeria, you have a Kudi, you have Kuda. I'm wondering, how can these two brands exist in the same space, offering very similar products, and that's just at the level of the brand name. If you go a little deeper to look at the business model or the business method that is adopted, or even the software that is deployed, used to build the app and so on, we find more and more similarities. In other places, companies use the IP system to create a unique selling point and exclude others, and just carve a niche in the market. So I think there's a space for that conversation, but I don't think it's one that we can have now, especially since I jumped in late. So I do apologize once again. Thank you very much for having me, and good stuff. Well done, everybody.
Thank you very much, Mr. Folari. Thank you for not allowing us to miss your intelligent points. Thank you, Favor. Thank you, everyone, once again. Have an amazing weekend. Bye.